Back at it. I know your schedule is pretty tight. So is ours. We go back in at 2 and we're going to calendar. So we're going to try to get this finished up. So, Mr. Chairman, as we left, we just kind of began on, we added the contents of 2168. And so we've heard from the revisers. So if you have more comments or where we can go from here, so go ahead.
I do not really, Mr. Chairman, thank you, have any comments other than I would like to put the contents of House Bill 2168 with the proposed amendment into the package that we're working on, 2047.
Okay.
And I'm happy to answer questions. I realize, Mr. Chairman, that when we left here earlier, your committee probably had places to go and you may not have had an opportunity to look at the amendment or discuss it amongst yourselves.
We have not. We've kind of all been different directions trying to get other things done. So thank you for that. Mr. Chairman, if we could, I know we have some folks here that we would like to hear from, and maybe you all would as well, just on this. So is Steve Carney back in here? Kate, would you be willing to speak? I'd like to call Katie Westman up, as she's kind of been working on this as well, if Steve Carney shows up. So again, just kind of explain this, maybe it's a little bit of how we've come to today.
Yes, thank you, Mr. Chairman. So Katie Wisman, I work on behalf of a group called Stand Up for Kansas right now. Many of you probably know me as formerly with the KBI as their executive officer. So in that capacity, I was very intimately involved in the when the Hemp Research Act and Hemp Commercial Acts were drafted and enacted into law. And so since that time, the KBI has been training prosecutors, law enforcement on particularly 2-3908, which is the statute that the amendment proposes to bring back in. And that contains explicit product prohibitions that constitute a violation of the Industrial Hemp Act. And so through the process of training law enforcement prosecutors, there's been some concerns raised with regard to enforcement action and whether those violations are more appropriately charged under 2-3908 and in what instances they would be charged under Chapter 21. So what this amendment proposes to do, and this is the product of several the past 3.5 to 4 weeks of collaboration with the KBI, Kansas County and District Attorneys Association, one of their drug prosecutors, the law enforcement associations, and me, just for historical knowledge, basically, is this proposes to create some clarification in terms of how those violations are prosecuted. So importantly, it's not creating any new violations. It's just simply saying these are the explicit product prohibitions that currently exist in 2-3908. And if there are violations, how to charge those. So right now, the threshold for violation is 0.3%. And what this would do is would increase that threshold for violation to 1% THC, which is compliant with the final rule that was issued by the USDA after the passage of the 2018 Federal Farm Bill. So it's raising that threshold to 1%, and it says any violations that are below 1% are charged under 2-3908, and any violations of those prohibitions that are above 1% THC can be charged under Chapter 21. In a nutshell, that is what this does. So it's not creating any new crimes. It's simply clarifying how these things are charged when there are violations that are investigated and enforced.
Jim again.
It's Senator,
I'm sorry,
Chairman.
But that's, thank you, Mr. Chairman. Yeah, I'm sorry. It's your ball. I apologize. It's old habits. Sorry.
So just, I have a few questions, but my first one just has to do with, did you say you worked on this for 3 or 4 weeks? Is that what you guys said? So I remember this bill being in committee like early this year, and I'm just kind of curious, did you guys testify in committee? I don't recall that.
No, to my knowledge, there was no testimony on this specific fix that's being presented in this amendment. It's something that has continued to come up through those training sessions and concerns by prosecutors. So this is something that's being brought as new language here. We just got the balloon amendment, I believe, on Monday afternoon, and had that circulated to KCDAA to make sure that it was, and continuing to work with Natalie. So it's a new balloon.
So you must have been concerned about illegal activities going on out there. Is there someplace that we can look to find out how much this is being abused, and that we need to have this? I'm trying to understand where all the abuse is at.
So I can't answer your specific question. I can't answer your question specifically, but what I can say is that it's enough of a concern with prosecutors and law enforcement in being able to take action against bad actors that are in violation of this statute currently, and just clarifying how those things are prosecuted.
But Mr. Kearney could probably maybe give me a little bit more background on that,
I
perhaps?
believe he could, and he was planned to be here, but he and Ed are both in different places, so you're stuck with me.
I don't have any questions. It looks like Senator Ware must have a question. Senator Ware.
I do, thanks. I've gotten a little bit more information since the last time we were in this room. What can you describe the testing equipment that you got that the KBI is currently using? Is it GC/FID? Is it gas chromatography port? What is it?
So appreciate your question. Super scientific and technical in nature. I left the KBI in 2020, so I don't know exactly what technology they're currently using, but I can tell you back then it was GCMS. I did also, made note of the question that you raised earlier, or the concern rather that you mentioned about how these tests are being reported. And I think, just for the edification of the committee, the way that THC concentration is defined currently under Kansas law with regard to the Hemp Act in Chapter 2 is in perfect alignment with the way that the federal government, pursuant to passage of the 2018 Federal Farm Bill, defined THC concentration. So to do something that would not consider the THC acid concentration in tests, which I believe is what you're alluding to, would be much more permissive of an interpretation of THC concentration than what the federal government currently allows.
Okay. So you don't know if it's liquid chromatography or what the process is currently that's used in anywhere in the state of Kansas?
I can't speak to that, but what I would say about this amendment is that nothing in this amendment changes the way that THC concentration is defined, measured, or reported.
Measured? Even testing and measuring aren't sort of the same thing?
This proposed amendment raises the threshold of a potential violation from 0.3% THC to 1% THC, which is compliant with the final rule, but nothing in here changes the way that THC concentration is currently defined in the Hemp Act.
Okay.
So that's, I think, the important part.
Well, the on the ground part is kind of important too. That's why I'm asking those questions.
Sure, appreciate that.
Mr. Chairman, we don't have any additional questions. Apparently, I don't know if your side of the room does.
Representative Carlin. Mike, yeah.
Thank you, Mr. Chair. As you talk about this and you cite KSA 23908, and I'm looking and I don't see very well right now, but I don't see it on this page of your balloon. And I would really like to have an opportunity to study and have someone walk me through KSA 23908. And I would like to know what the crime is, what the level of severity is, and how many months in prison and all that stuff, because that's what this is about. And I don't remember those things. I haven't dealt with that for a while.
Yeah,
So
so
level 4 to 1 is pretty severe in most cases. That's a severe level of felony. And I would have to know what that was before I could move forward on this.
So this whole balloon that you have, attachment 1, is 2-3908, but I think it's probably more appropriate for the reviser to walk through. Yeah.
Natalie.
Sure. Thank you, Mr. Chairman. And I just want to clarify, because and this could be a potential drafting issue if what I understood Katie to say is accurate. This balloon does not raise the threshold for a violation of this section from 0.3% to 0.1%. It would still be a violation if you have something that's 0.4%. But anything that's a violation that's under 1% is going to be subject to the current law penalties that you have in this act. And then anything that would be a hemp substance that has a concentration above 1.0% or above, that's when this is trying to direct you over to the criminal code. So I just want to clarify, and maybe Katie can correct me if that's not what she intended with the draft. But in terms of what this section prohibits, if you look at subsection A1, that's kind of where the key prohibition is. So it shall be unlawful for any of the following hemp products to be manufactured, marketed, sold, or distributed by any person in the state of Kansas. And then you have that list: the cigarettes, cigars, chew, teas, liquids, any other hemp product intended for human or animal consumption, containing an ingredient that's prohibited pursuant to the Kansas Food, Drug, and Cosmetic Act, or the other various acts. So distributing or selling those products with, even if they contain industrial hemp, would be a violation of this act. And the current penalties for that are: on a first conviction, you have a Class A non-person misdemeanor that carries the potential jail time of up to a year. On a second offense, you have a severity level 9 non-person felony. That's going to be presumptive probation for folks, and your penalty is going to be somewhere in the range of like 7 to 12 months, I think, off the top of my head. So less than a year on probation. Now, what this balloon does is if you are dealing with a hemp product that is above 1% THC, so it could otherwise have been a valid product to be sold as hemp, but the concentration is above 0.1 or above 1.0% THC, then those are going to be prosecuted under the criminal code section. So, for example, distribution of a controlled substance, and that's going to be a drug felony. So up to 25 grams of marijuana is a drug severity level 4. And then depending on the weight of that, it goes up to a drug severity level 1 felony. Let me pull that grid up, sorry. So for a drug severity level 4, if you have no criminal history, you're in a border box territory, which means there's no presumption as to whether you're going to go to prison or be on probation. But the range is 14 to 16 months. And then as you go up, depending on the amount of product that you have, the highest level would be 154 months at presumptive prison.
Go ahead.
Thank you very much for that information, and thank you, Travis. To me, and I've worked on the corrections and juvenile justice oversight, and I served on corrections years ago. This is not for this kind of a deal. Doesn't seem to be an ag committee thing to me. It seems to me like we're talking here. What's going to happen is changes. I mean, I understand that's our product and our bill that we started, the hemp bill, and I was there when we did that. But it seems to me like we're now going to punishment, which might be better in a judiciary or corrections committee, and I'm uncomfortable. Thank you, Mr. Chair.
Okay. Yeah,
Looks like we have a couple questions over here,
go
Mr.
ahead.
Chairman.
Yes, go ahead.
Senator Ware and then Senator McGinn.
Thank you, Mr. Chairs. For the revisor, I think. Do we have the exact definition from the Farm Bill, or could we get that? There seems to be some discrepancies between this and the Farm Bill.
Mr. Chair, I'll let one of the ag, they're kind of more familiar with the actual hemp act provision, so I'm sure they could probably find that for you.
Specifically as to the percentages, that sort of thing.
While they're looking for that, Senator McGinn.
Thank you, Mr. Chairman. I just was looking at the original title, and this bill has to do with fee registrations. And we're getting into, after listening to Natalie, I felt like I was in judiciary again. But I guess my question once again is for Ms. Wisman. I just need help understanding who are we going after? Because the bill is about helping industrial hemp producers, and now I feel like, I hope it's not our industrial hemp producers that we're going after. I feel like we're going after a whole different entity that should be in a whole different bill and has nothing to do with hemp fees. So can you help me? Who are we going after? The people that are doing the bales of hemp, or are we going somewhere else?
Before you answer that, I might just make you aware, Senator McGinn, that KSA 23908 was in original House Bill 2168. The House took it out, which is their prerogative, and created a substitute bill. Katie, go ahead and answer the question.
Yeah, so I wouldn't say that we're necessarily trying to go after anyone in particular. I think the goal of this is the product prohibitions that currently exist in 2-3908. Those are currently explicit violations. And so the first subsection says that it's unlawful for any person in Kansas to possess, distribute, offer for sale certain things, like Natalie ran through the list: hemp teas, tobaccos, vape cartridges, those things. The second piece of that says that if you're a licensed producer, that you cannot legally distribute hemp floral material, for example, to an unlicensed entity. And so the goal of that is making sure that hemp floral material, for example, isn't offered for sale in a way, because it just creates a lot of confusion for law enforcement. They look the same, they smell the same. Is that hemp? Is that marijuana? How do we enforce that? How do we do so in a way that is consistent with the intent of the Industrial Hemp Act and the Commercial Act? So this piece is not necessarily positioning law enforcement to go after any certain type of entity, other than the people that are currently in explicit violation of that hemp product prohibition statute, and clarifying how they may be charged.
Staff, have you gotten an answer for Senator Ware?
Yes, thank you, Mr. Chairman. So the Farm Bill defines hemp to mean the plant Cannabis sativa L and any part of that plant, including the seeds thereof, and all derivatives, extracts, cannabinoids, isomers, acids, salts, and salts of isomers, whether growing or not, with a delta-9 THC concentration of not more than 0.3% on a dry weight basis.
Senator Ware?
Thank you. And does that match what we're looking at here?
The Commercial Industrial Hemp Act does define industrial hemp, and it also includes all of those things that contain a delta-9 THC concentration of not more than 0.3% on a dry weight basis.
So, Mr. Chairman, I guess I will just hand it off to you.
Okay. And again, I want to make sure I fully understand too, because we worked a couple of years ago, the 0.3 on products and all that, or was 4 years ago already? Seemed like it was yesterday. So Natalie, as you were explaining, if this were to go, the THC level, I'm hearing 1%, but I'm also hearing if you're over 0.3. So explain to me the gap from 0.3 to 1.
Uh, Thank you, Mr. Chairman. I will explain it the way that I think the balloon does it. And if Katie has a different understanding, then she can speak up. So in order, we're not changing anything about the definition. Tamara read to you the definition of what is required for it to be considered a hemp product. It's got to be 0.3% or lower. But say you have a violation of this act where someone is trying to distribute a tea, for example, and it's 0.2% THC. Well, that's under the THC threshold, but it's still a violation of this act because you can't have the teas. So that is going to be is the hope of this balloon going to be prosecuted under this section. So the potential penalties there are a Class A non-person misdemeanor and then a severity level 9 non-person on a second conviction. If you have a violation of the act that otherwise is a perfectly okay industrial hemp product, mulch, something like that, and the THC concentration falls somewhere between 0.3% and 1%, so say it's 0.5%, then you're still going to fall under these penalties here in this section. But if you have a product, whether it be mulch or tea or whatever, that is a THC concentration over 1% or over, then what this section is trying to do is direct prosecutors to say they should be prosecuted under the criminal code provision for distribution of a controlled substance instead of for violation of this act. And so if that's my understanding, but Katie can.
So you have this whole list of unauthorized products, but I guess I'm still not making that connection. So regardless of what percentage, if you have one of these products, you're busted in a sense. Does the 1% give the prosecutors some leniency, or am I reading more into it than I should?
Mr. Chairman, I wouldn't call it leniency. I think when a prosecutor is presented with that issue right now, they have to make a decision about whether they think that violation should be charged under this section or whether that violation should be charged under distribution of a controlled substance. And you get into some kind of technical issues when you have two crimes that have identical elements of those crimes. That's where the new subsection D comes into play. So this is an attempt to say, if you're violating this act, but your THC level is below 1%, then these are the penalties that, are viewed as appropriate. But if you're above 1% THC, then we want prosecutors to deal with those people under distribution of a controlled substance, and then they'd be drug felons.
Okay, very good. Okay, thank you.
And Mr. Chairman,
Yes.
The reason that I am bringing this forward is to make certain that hemp is hemp and hemp growers do not get out of their lane. Is the real reason, just to cut to the chase, why I am presenting this in conjunction with 2148.
Okay. All right. Very good. I know we're going back in at 2. We're going to calendar, so I think let's go ahead and push through this. And if you have time, let's keep moving. Mr. Chairman, I would like to bring we've had a lot of other ag bills that have been successful, at least on our side, that we put into this deal. As we kind of try to put this all together in a package, I'd like for Aaron Papalka to come up again and maybe talk about this and maybe how this kind of fits into kind of the offer, the package we have right now. So, Aaron, if that's all right, if you would.
Thank you, Mr. Chairman, members of the committee. I don't necessarily have an opinion on the substance of the amendment. I think my concern for the association would be more on process. We're at a point where I don't think this has been introduced in bill form, has not had a hearing, went through committee, passed the floor, where every bill that's been in here, whether it's brands or poultry or facilities, has. We know how many votes it'll get in a chamber at least. And the concern is if this is added, given the consternation, what does it do to the underlying ag centric package? So that's a decision for you all. That would be our only concern is can we get enough votes to not just pass this, but then also we don't know the governor's stance on this. And so if she would not be for it, then we would need to get 84 or 27 to make these good, really good ag products that you've all done and packaged across the finish line. So that's our concern, but that's kind of a realm for you all. Thank you.
Well, no, we're gonna. Any questions from the Senate side on that?
Apparently not.
Okay, we're gonna stay right here, but let's break for just a couple of minutes. We'll discuss. Kyle or one of you come over here? I think we have some just questions to make sure we fully understand moving forward. Let's take about 3 to 5 minutes, and then we come back to the microphone. We'll come. I think our assistant's on the line to make sure we're not going to get kicked out, because I think we were only here till 2, and so we're after 2. But I guess we'll go till they kick us out. Mr. Chairman, we've had a lot of discussion on this, and um, what resonates with me, and I do appreciate that, is to in a sense protect hemp growers, protect the industry. I think we've both been involved since it was a research project, K-State, and now where it is. In light of that, I wonder. Uh, we don't have plurality on this side on this. I am wondering if we don't have any other place to go with it here in committee. And, if there's a possibility, if there's another, I don't know what judiciary has. I don't know what others possibly might have that would work. This may be the best and only opportunity for this year. I don't know. With the other bills that we have, and I do, like I say, I appreciate, um, probably the urgency and the importance of this. I think, I think we would be more than, I would like to work with you moving forward on hemp. And I think the way we approached this year was, I was kind of focused on what I believe we heard from the industry is they want more growers and they wanted a lower fee. And that's why I did the gut and go on simply attacking the fees and not going into something like this, because I felt that maybe we weren't quite there yet because of what the support was for the industry from growers, from farmers in Kansas. And so, I think we have had a quick education, but there's still a lot of questions with some of these situations. And one of the concerns that has been expressed here is, what does that mean to other legislation that we have worked on? And I know there's a couple that you have not had on your side, not worked on your side. I understand that, but I don't believe that our side can support this, adding this bill and the amendment to this package.
Mr. Chairman, I understand that, so we will withdraw the offer to put 2148 into the package, and that will simplify on this issue. And I'll see if there is another vehicle in another committee or something that will work. If not, we'll see who is back next year and who are the chairs of the various committees, and urge that they take a deep dive into this topic. But I wanted to see if we could get this across the finish line, and that's the reason that it was pushed. And I appreciate the time. We've invested a lot of time, a significant amount of time, on an issue that I'd been working on for a few weeks, but it took a while to get it all together. And so anyway, I appreciate you taking the look, and I understand the heartburn and not allowing. We do have a couple other bills that we have not heard. 2800, we didn't get it until the last day we met, and so I'm going to pull that back from the combined bill, since it has not been heard in the Senate committee, nor has it run across the Senate floor. I know it went across, it is conferenceable. It ran across the House floor, but I'm going to pull that one back. We have another bill that was heard in committee, was not worked in committee, did not run across the Senate floor, and that is 2608. And so I'm going to ask that we pull back on that one. So 2047 will remain as it came to us, or potentially amended. 2543, the Brands bill with the amendment, willing to agree to those. So I guess that would create a 2-bill package for this conference.
Okay, well, and I understand. Um, 2,800, I think, is one that is very non-controversial. There's 105 conservation districts in every one of our districts. This is helping some of the lowest paid people to do a lot of work. But I also understand procedure, and I'm not I do not discount that that uh, and in light of other things that have gone on, I understand as we've gone through this. Give us just a minute or two here. We'll just pull back right quick. We'll discuss your offer, and then we'll come right back. Okay. Okay. We would be in agreement that the conference committee would entail 2047 and 2543. Correct. Okay. And then what we will look at maybe other ways for those other bills and go through a possible the process somewhere. I don't know as far as 2,800 was an appropriations bill. And so possibly look at an omnibus, maybe, I don't know at the end, if there's a way, I don't know, just as we're looking, but I understand the procedure. So that'd be fine.
Mr. Chairman, Senator McGinn has a question. Go ahead. We do, Mr. Chairman, have a bill out or this in conference 2607. Is it still your intent to concur with the Senate amendments, or do you know your intent with 2607?
Oh, yes, I'm sorry. We concurred on that yesterday. And so I just have not been on the floor long enough to get with leadership. And so we will concur on that with your amendments. So hopefully run it, if not tonight, maybe probably tomorrow morning. Yes, thank you.
So you say we're going to be here overnight into the morning? No, I'm
I was
sorry.
here till almost midnight last night, so no, I hope so. So do good work in tax. Okay, so are we in agreement then, ready for the conference, for the committee report then?
I'm
On
in
that?
agreement.
Okay. Anything else to go to the cause? Thank you, staff. Appreciate it. We probably are on the floor, so we are adjourned.